Good morning, attorney. Good morning, everyone. I'm Aline Panopio, and I'm the first reporter for Group 5. So my first case is the case of Acosta versus Ochoa et al. So this is a recent case in 2019. So the facts of the case is Eric Acosta and Nathaniel de la Paz, they are holders of licenses for firearms, have submitted a legal petition to the Supreme Court. They are challenging the constitutionality of several sections of Republic Act 10591 of the 2013 implementing rules and regulations, which is the requirement in the firearm registration application form that obligates them to consent to voluntary inspection, claiming that it violates Article 3, Section 2 of the Constitution, which safeguards against unreasonable searches and seizures. So on the same day, Peaceful Responsible Owners of Guns Incorporated or ProGun, a nonprofit organization representing licensed gun owners in the Philippines, filed its own legal petition with the Supreme Court. They sought certiorari prohibition and mandamus relief, along with a request for a temporary restraining order or preliminary injunction. So their petition challenged the requirement for firearm license applicants to waive their privacy rights and allow police entry into their homes, arguing that this violated Article 3, Section 2 of the Constitution. The Guns and Ammo Dealers Association of the Philippines, or the Guns and Ammo Dealers, purpor- purportedly an organization representing around 50 authorized firearms dealers in the Philippines, also filed a petition for mandamus and certiorari. So these cases were later eventually consolidated. So in essence, the petitioners contend that the RA number 10591 and its implementing regulations unreasonably limit their rights to possess firearms, property, and privacy. On the other hand, the government, represented by the Philippine National Police, argues that owning and carrying firearms is a privilege, not a right. Therefore, individuals seeking a firearm license must either accept or decline the government's terms for firearm use and possession. So, the issues for this case, we have two. Um, so first is whether or not the signing of the consent of voluntary presentation for inspection violates Article 3, Section 2 of the Constitution on the protection against unreasonable searches and seizures. So, the first issue, yes. So the obligation for inspection as outlined in Republic Act number 10591 as interpreted by the Philippine National Police in their implementing rules does not qualify as a reasonable search. The definition of a reasonable search hinges on whether an individual has a reasonable expectation of privacy as determined by societal standards. The existence of this expectation and society's acknowledgement of its reasonableness categorizes the state's intrusion as a search within the context of Article 3, Section 2. Such intrusion would necessitate a search warrant. There is a strong, nearly absolute presumption of privacy within one's residence. Furthermore, signing the consent of voluntary presentation for inspection could be considered an ineffective waiver, since it might not be given willingly, voluntarily, or with full awareness by the applicant, who might sign it under duress, fearing that their application would otherwise be denied. So in the second issue, um, whether or not the requirement of a license to own and operate a firearm, but a violation of petitioners' rights to bear arms. So in this issue, the Supreme Court held that no, the right to bear arms in our jurisdiction has always been and it still is a privilege granted by statute, tightly controlled by the state. None of our constitutions have ever explicitly recognized the right to bear arms. Carrying arms was viewed as a discretionary choice, and a citizen desiring to acquire a firearm, they must comply with the conditions imposed by the government. Presently, the right to bear arms remains a mere statutory privilege, not a constitutional entitlement. So given that the right to bear arms is a privilege granted by the state, there is no infringement on the petitioner's due process rights in mandating a license for firearm possession. Article 3, Section 1 of the Constitution clearly specifies that only life, liberty, or property is safeguarded by the due process provision. It is firmly established that the license to possess a firearm does not constitute property. Similar to any other permit, the firearm possession license is neither property nor a property right, as a mere authorization or privilege to engage in what would otherwise be unlawful. It does not establish a contractual relationship between the granting authority and the individual to whom it is issued. So, the second case um, that I will report is Concha versus People, which is held in 2018. So the facts of the case is that a Honda Wave motorcycle owned by Cacho was forcibly taken by four individuals from his nephew Makotay. The incident occurred on February 15, 2006, after Makotay had borrowed the motorcycle from Cacho and was driving it with his uncle and cousins as passengers. While traveling near Lauanan and Liwanag, the motorcycle got a flat tire, and the group decided to push it. They encountered a parked white car on the road from which four armed individuals emerged, declaring a holdup. The armed men took Makotay's belongings and instructed him to flee, then left with the motorcycle, leaving the sidecar behind. On February 21, 2006, Makotay identified three individuals, including Managelot and Concha, as the robbers at the Tumawini police station. He later testified against them, leading to their conviction for carnapping by the Regional Trial Court on November 10, 2010. Concha and Managelod appealed to the Court of Appeals, arguing that the out-of-court identification was invalid because it was conducted through a police show-up. They raised two main issues: the admissibility of the out-of-court identification and their guilt beyond reasonable doubt. The Court of Appeals upheld their conviction, finding no impermissible suggestion during the police lineup. However, the appellants questioned the validity of the out-of-court identification in their petition for review on certiorari. So the issue in this case is whether or not the out-of-court identification of Melky Concha and Romeo Managelot is admissible. And the Supreme Court held that no. Upon reviewing the case, the court determined that the out-of-court identification did not meet the necessary standards as Makotay failed to provide adequate descriptions of the attackers. His intention was compromised due to fear and confusion. There was no prior description to support his identification. The identification process was tainted with police influence. As a result, the court reversed the Court of Appeals decisions and acquitted Concha and Maniguelo due to reasonable doubt. Okay, so the third case that I will report is People versus Moreno, which is held recently in 2020. So the facts of the case is that on November 16, 2001, at around 2:15 a.m., Adel Riza Mijares was abruptly awakened when a man violently attacked her husband, Cecil Mijares, in their home. Despite the act, Despite the attack, Cecil managed to repel the assailant who fled the scene. The police arrived at the scene and observed multiple stab wounds on Cecil's body. Adel Riza, the sole witness, vividly described the attacker's appearance to the police. A sketch of the suspect was drawn based on her description. Later that day, acting on a tip from a neighbor who had heard rumors about the suspect, the police invited Gerald Moreno to the station for an interview regarding the crime. Adel Riza, summoned to the station, positively identified Moreno as her husband's assailant. The police arrested the appellant and informed him of his constitutional right to remain silent and to have a competent counsel of his choice. The appellant, however, did not respond. So the trial court, after considering the evidence presented, found the appellant guilty of murder. The Court of Appeals upheld this decision. Hence, in this appeal to the Supreme Court, Moreno questioned the legality of his identification, arrest, and custodial investigation. Specifically, he alleged the irregularities in these processes and violation of his constitutional rights. So the issue in this case is whether or not the lack of a police lineup for identification and alleged violations of his rights to counsel remain silent and due process during the investigation invalidate the case against him. So the Supreme Court ruled in favor of the prosecution, upholding Moreno's conviction for murder. The court stated that a police lineup is not indispensable for the proper and fair identification of offenders. What matters most is the victim's positive and credible identification of the suspect as the perpetrator. In this case, Adel Riza's eyewitness testimony given shortly after the incident and corroborated by her description of the suspect was found to be clear, positive, and credible. The court applied the totality of circumstances test to determine the reliability of the identification and found it to be admissible. Regarding Moreno's arrest, the court emphasized that objections to the manner of arrest should be made before arraignment. Since Moreno only raised this objection on appeal, it was deemed waived. Even assuming irregularities in the arrest, there were not considered jurisdictional defects. Furthermore, the court found no violation of Moreno's right to counsel during custodial investigation. Since he chose to remain silent, he was not interrogated and no statement or evidence was obtained from him during the investigation. So my fourth case is Villanueva versus JBC, which was held in 2015. So the facts of the case here is that the petitioner was appointed as the presiding judge of a first-level court in 2012. In 2013, he applied for vacancies in second-level regional trial courts. He was informed that he was not included in the list of candidates for these positions. In response, he protested, arguing that some applicants who did not pass the prejudicature examination were included. The Judicial Bar Council, or JBC, upheld its decision not to include him due to its policy of requiring at least 5 years of service as a judge in first-level courts for eligibility in second-level courts. Dissatisfied, the petitioner sought recourse in the Supreme Court. So the issue here is whether or not the Judicial Bar Council's policy of requiring 5 years of service as judges of first-level courts before qualifying as applicants to second-level courts is constitutional. So the Supreme Court held that yes, that the said added 5-year qualification being assailed by the petitioner is constitutional since, as stated in the Section 8, Paragraph 5 of Article 8, the JBC is mandated to recommend appointees to the judiciary. Consequently, it was also stated in the said provision that only the persons nominated by the JBC is transmitted to the president that will choose whom to nominate as judge in the judiciary. In this case, it is clear that the JBC does not fall within the scope of a tribunal, board, or officer exercising judicial or quasi-judicial functions. In the process of selecting and screening applicants, the JBC neither acted in any judicial or quasi-judicial capacity, nor assumed unto itself any performance of judicial or quasi-judicial prerogative. However, since the formulation of guidelines and criteria, including the policy that the petitioner now assails, is necessary and incidental to the exercise of the JBC's constitutional mandate, a determination must be made on whether the JBC has acted with grave abuse of discretion amounting to lack or excess of jurisdiction in issuing and enforcing the said policy. Besides, the court can appropriately take cognizance of this case by virtue of the court's power of supervision over the JBC. Jurisprudence provides that the power of supervision is the power of oversight, or the authority to see that subordinate officers perform their duties. Following this definition, the supervisory authority of the court over the JBC is to see it that the JBC complies with its own rules and procedures. Thus, when the policies of the JBC are being attacked, then the court, through its supervisory authority over the JBC, has the duty to inquire about the matter and ensure that the JBC complies with its own rules. And my last case for my report is Biraoga versus Philippine Truth Commission. So this case was held on December 7, 2010. So the facts of the case is President Aquino signed Executive Order number 1 on July 30, 2010, establishing the Philippine Truth Commission of 2010, or the PTC. So the PTC is an ad hoc body under the Office of the President tasked with investigating graft and corruption committed by certain public officials during the previous administration. It has investigative powers, but it is not a quasi-judicial body and cannot adjudicate disputes or render awards. PTC can gather evidence and make recommendations, but cannot determine probable cause or file information in courts. Petitioners sought to declare PTC unconstitutional and prevent it from functioning. So the issue at hand is whether or not Executive Order number 1 violates the principle of separation of powers by usurping the powers of Congress to create and to appropriate funds for public offices, agencies, and commission. So the Supreme Court held that no, there will be no appropriation but only an allotment or allocations of existing funds already appropriated. There is no usurpation on the part of the executive of the power of Congress to appropriate funds. There is no need to specify the amount to be earmarked for the operation of the Commission because whatever funds the Congress has provided for the office of the President will be the very source of the funds for the Commission. The amount that would be allocated to the PTC shall be subject to existing auditing rules and regulations, so there is no impropriety in the funding. So let's just review our discussion. So in the first case, um, note that um, the main doctrine of the case in relation to due process and equal protection in the Philippine Constitution affirms its implementing regulations of RA number 10591 regarding firearm ownership and regulation. So um, in that case, the unreasonable search and seizure that the court ruled that the requirement for firearm license applicants to sign a consent of voluntary presentation for inspection, which allows police entry to their homes, violates Article 3, Section 2 of the Constitution, which safeguards against unreasonable searches and seizures. So it emphasizes that individuals have a strong presumption of privacy within their residences, and such intrusions should require a search warrant. Also, the firearm ownership, the case also tackles the firearm ownership as a privilege, and the court reaffirms that the right to bear arms in the Philippines is not a constitutional entitlement, but rather a privilege granted by statute, and tightly controlled by the states. It also clarifies that the license to possess a firearm does not constitute property and therefore does not fall under the protection of due process rights related to life, liberty, or property. In the second case, so the main doctrine that we should note in the Concha versus People case is that in the relation to due process and equal protection, in the Philippine Constitution, underscores the importance of adhering to due process rights, particularly in the context of out-of-court identifications. It highlights that for an out-of-court identification to be admissible, certain standards must be met, including the absence of impermissible suggestion, a clear and reliable description from the witness, and an undated identification process. So this doctrine reaffirms the principle that the right to due process and equal protection under the law should be upheld in criminal proceedings, ensuring fairness and protecting the rights of the accused. Um, so in the third case, in People versus Moreno, the main doctrine here is derived from that was derived from the case is that in the Philippines, uh, a police lineup is not essential for a proper and fair identification of suspects. What is crucial is the witness clear, positive, and credible identification of the alleged offender. So this doctrine reinforces the principles, again, of due process and equal protection under the Philippine Constitution, ensuring that a person accused of a crime is treated fairly and justly, and that evidence against them is obtained in a lawful manner with respect for their constitutional rights. In the fourth case, Villanueva versus JBC. So please take note the main doctrine of the case in relation to due process and equal protection in the Philippine Constitution affirms the constitutional authority of the JBC in recommending appointees to the judiciary. So it highlights that the JBC's policies, including qualification for judicial applicants, are constitutional as long as they are necessary and incidental to the exercise of the JBC's constitutional mandate. So the case also emphasizes that the JBC, while not a tribunal or quasi-judicial body, it plays a critical role in the selection and screening of judicial candidates. Therefore, the court has the power to supervision over the JBC to ensure compliance with its own rules and procedures. So this doctrine also underscores the importance of upholding the integrity of the judicial selection process, while also recognizing the court's supervisory role in safeguarding constitutional processes. Okay, and then the last case, let's review that the main doctrine of the case in relation to due process and equal protection in the Philippine Constitution affirms the constitutionality of Executive Order Number 1, which established the Philippine Truth Commission of 2010, or the PTC. It highlights that EO number 1 does not violate the principle of separation of powers, by usurping the powers of Congress to create and appropriate funds for public offices, agencies, and commissions. It also underscores that Executive Order Number 1 does not involve a direct appropriation of funds, but rather the allocation of existing funds already appropriated for the office of the President. This allocation is subject to existing auditing rules and regulations, ensuring transparency and proper use of funds. Therefore, the executive's action in creating the PTC and allocating funds from its existing budget does not overstep its constitutional bounds in the separation of powers. So this doctrine upholds the legality of executive actions aimed at addressing corruption and promoting accountability within the confines of constitutional principles. So that is uh, that is my report. Thank you for listening, and now let's hear the next reporter, Mr. Navarro.
Hello, classmates. I am Jose Gianmarco B. Navarro, and I will be continuing the reports on the Equal Protection Clause. So now we go to the case of Quinto versus Comelec. So the facts of the case are as follows. In December 1997, Congress enacted RA number 8436, or an act authorizing COMELEC to use an automated election system for the May 11, 1998 national and local elections, and also in subsequent national and local elections. Said law had a provision stating that any elective official, whether national or local, running for any office other than the one which he or she is holding in a permanent capacity, except for President and Vice President, shall be deemed resigned only upon the start of the campaign period, corresponding to the position for which he or she is running. So, 10 years later, or in January 2007, Congress passed an amendatory law, RA 9369, and Section 13 of the said law provides that any person holding a public appointive office or position, including active members of the armed forces and officers and employees in government-owned or controlled corporations, shall be considered ipso facto resigned from his or her office and must vacate the same at the start of the day of the filing of his or her certificate of candidacy. So, in line with this amended law, COMELEC issued resolution number 8678, which provided the rules on filing of the COCs for the May 10, 2010 national and local elections. Now, Section 4A of the resolution was substantially the same. It mirrored practically Section 13 of RA 9369. So, the petitioners in this case, they were alarmed that they will be deemed ipso facto resigned from their offices the moment they filed their COCs. Petitioners Eleazar Quinto and Herino A. Tolentino Jr., who hold appointive positions in the government and who also intend to run in the coming elections, filed this instant petition for prohibition and certiorari, seeking the declaration of the aforequoted Section 4A of Resolution 8678 as null and void. So the issue presented to the Supreme Court is whether or not Section 13 of RA 9369 and Section 4A of COMELEC Resolution 8678 is unconstitutional for being violative of the Equal Protection Clause. And the Supreme Court answered yes. So, yes, in considering persons holding appointive positions as ipso facto resigned from their posts upon filing of their COCs, but not considering as resigned all other civil servants, specifically the elective ones, the law unduly discriminates against the first class, the public servants who are in appointive positions. The fact alone that there is a substantial distinction between those who hold appointive positions and those occupying elective posts does not justify such differential treatment. So in this case, the Supreme Court also reiterated the four requisites for a valid classification. So, in order that there can be a valid classification so that a discriminatory governmental act may pass the constitutional norm of equal protection, it must comply with the following four requisites. So, one, it must be based upon substantial distinctions. Two, it must be germane to the purpose of the law. Three, it must not be limited to existing conditions only. And four, it must apply equally to all members of the class. So, the first requirement means that there must be real and substantial differences between the classes treated differently. Second, as for the second requisite, even if there is a substantial distinction between the classes, the classification would still be invalid if it is not germane to the purpose of the law. Next, the third requirement means that the classification must be enforced not only for the present, but as long as the problem sought to be corrected continues to exist. So it has to be enforced even prospectively. Last is the classification would be regarded as invalid if all the members of the class are not treated similarly, both as to rights conferred and as to obligations imposed. So, applying the four requisites to the instant case, the Supreme Court finds that the differential treatment of persons holding appointed offices as opposed to those holding elective ones is not germane to the purpose of the law. In other words, there is a violation of the second requisite. So now we go to the illustration. So in this case, the Supreme Court actually gave an illustration to drive the point. It's a bit exaggerated, but let's bear with them for now. So in this case, the Supreme Court illustrated that suppose we make a classification between men and women. So classification, men, women. The substantial distinction between them would be physical strength and stamina, because in the Supreme Court's words, they held that it's commonly held that an average man has more physical strength than an average woman. Their words, not mine. So next, suppose um, two different laws were passed, and their purposes are as follows. So one, the first law, let's say Congress passes a law prohibiting the employment of women in physically strenuous jobs such as coal mining and stevedoring. The Supreme Court held here that such classification is valid because it is germane. The premise is the differential strength between an average man and woman. So, if the purpose of the law is to prohibit or restrict employment in physical strenuous jobs between men and women, then it is valid. Now, on the other hand, if a law is passed providing for a lower passing average for women in the bar exam, now the distinction between men and women on the basis of physical strength is not germane to the purpose of the law, because physical strength and stamina between male and women has no bearing as to the competency of a woman to pass the bar exams. So this is how the Supreme Court illustrated the issue. So now, going back to the case. So the obvious reason for the challenge provision is to prevent the use of governmental position to promote one's candidacy or even to wield a dangerous or coercive influence on the electorate. The restriction is also justified by the proposition that the entry of civil servants to the electoral arena while still in office could result in neglect or inefficiency in the performance of duty because they would be attending to their campaign rather than to their office work. Indeed, whether one holds an appointive office or an elective one, the evils sought to be prevented by the measure remain. Thus, there is no valid justification to treat them differently when both filed their COCs for the elections. Wherefore, the petition is granted and the assail provisions are declared unconstitutional. Case of Philippine Association of Service Contractors Inc. versus Franklin Drilon as Secretary of Labor and Employment. So the facts of the case are as follows. This is a petition for certiorari and prohibition assailing the constitutionality of Department Order Number 1 issued by the Department of Labor and Employment, or DOLE. The order laid down guidelines of the temporary deployment ban of female domestic workers in the states of Iraq, Jordan, Qatar, Canada, Hong Kong, United States, Italy, Norway, Austria, and Switzerland. Specifically, the measure was assailed for discrimination against males and females, that it does not apply to all Filipino workers but only to domestic helpers and females with similar skills, and that it was violative of the right to travel and likewise an invalid exercise of the lawmaking power because police power is legislative and not executive in character. For the purposes of this report, we will be focusing on the Equal Protection Clause. Hence, the issue before us is whether or not Department Order Number 1, which provides a temporary deployment ban of female domestic workers, constitutes a violation of the Equal Protection Clause. And the Supreme Court held that no, there is no undue discrimination between the sexes. It is well settled that equality before the law under the Constitution does not import a perfect identity of rights among all men and women. It admits of valid classifications provided that they satisfy the following requisites. So, one, it must be based upon substantial distinctions, it must be germane to the purpose of the law, it must not be limited to existing conditions only, and it must apply equally to all members of the class. So in this case, the court is satisfied that the classification made the preference for female domestic workers and that it rests on substantial distinctions. So why? Why did the Supreme Court say that there was a substantial distinctions between the classes? So the court took judicial notice of the fact that there is an unhappy plight that has befallen our female labor force abroad, especially domestic servants, amid exploitative working conditions marked by physical abuse and personal abuse. The sordid tales of maltreatment suffered by migrant Filipino workers, even rape and various forms of torture confirmed by testimonies of returning workers, are compelling motives for urgent government action. As precisely the caretaker of constitutional rights, the court is called upon to protect the victims of exploitation, and in fulfilling that duty, the court sustains the government's efforts. Now, the same cannot be said of our male workers, for in the first place, there is no evidence, except perhaps for isolated or remote instances, that our men, our Filipino overseas workers abroad, have been afflicted with an identical predicament. Thus, the court finds that the guidelines apply to all female domestic overseas workers. It does not apply to all Filipina workers. Hence, it will be remembered that the argument brought forth was there was a discrimination between the sexes, but as can be seen here, the ban is not effective on all female workers. It is only affected on female domestic workers because of the fact that there has been a rise in there has been a rise of instances of abuse towards them abroad. So, um, had the deployment ban been affected to all female workers, then that classification would have been unreasonable or arbitrary because not all Filipino workers are similarly circumstanced. So, what the Constitution prohibits is the singling out of a select person or group of persons within an existing class to the prejudice of such a person or group or resulting in an unfair advantage to another person or group of persons. For example, applying the ban, say, exclusively to workers deployed by Company A but not to those recruited by Company B would obviously clash with the Equal Protection Clause of the Charter. But as extensively discussed, um, the deployment ban is not um, discriminating against like Agency A, Agency A's domestic workers as opposed to Agency B's domestic workers. No, it is being applied equally to all agencies, agency or companies' domestic workers. All domestic workers are being banned to travel abroad because of all the aforementioned reasons that there's a rise in abuse and torture and even rape. So, wherefore the petition is dismissed. Discuss the case of Department of Transportation versus Philippine Petroleum Transport Association. So, just the background first. In December 2005, a power barge ran aground off the coast of Antique, dumping 364,000 liters of bunker oil. This oil spill severely polluted 40 kilometers of Antique's coastline and decimated more than 230 hectares of pristine mangrove forest. The rehabilitation costs have been estimated at 1 million US dollars. Now, a few months after the Antique incident, or on August 11, 2006, a Petron chartered single hull vessel carrying 2.1 million liters of oil sank in the Guimaras Strait, causing the Philippines' worst oil spill. It was dubbed an ecological time bomb. The sunken vessel leaked an estimated 100 to 200 liters of oil per hour, while roughly 320 kilometers of coastline was covered in thick sludge. Miles of coral reef and mangrove forests were laid to waste, and more than 1,100 hectares of marine sanctuaries and reserves were badly damaged. And with all fishing activities put to a halt, around 40,000 people were affected. So, recognizing the gravity and extent of the Guimaras oil spill, the lack of proper response strategy, also the absence of necessary equipment for containing and cleaning up oil spills, as well as the difficulty in pinning the liability on oil companies, Congress passed RA 9483, or the Oil Pollution Compensation Act of 2007. So, Section 22A of this law that Congress passed provided for the establishment of an oil pollution management fund. It mandates that contributions from owners and operators of tankers and barges hauling oil for petroleum products in the Philippines, um, they shall be charged an amount of 10 centavos per liter of oil that they are transshipping. So, um, due to the imposition of this law, um, the respondent Philippine Petroleum Transport Association, Inc. contends that it violates the Equal Protection Clause as it unduly discriminates against owners and operators of petroleum tankers and barges. So, the issue before us is whether or not Section 22, Paragraph A of RA 9483 is violative of the Equal Protection Clause. And the Supreme Court held that no, separating tankers and barges hauling oil for petroleum products in the Philippine waterways from other seaborne vessels does not violate the Equal Protection Clause. So, the Supreme Court reiterated its ruling in the case of Abacada Guru Party List versus Purisima. Once again, it enumerated the four requisites for valid classification, of which we are already familiar with from our previous case discussions. And furthermore, the Supreme Court expounded that it held that the standard for classification is satisfied if the classification is based on a rational basis and is not palpably arbitrary. Furthermore, the court cannot subscribe to respondents' proposition that since all vessels plying the Philippine waters are susceptible to accidents which may cause oil spills, all should be made to contribute to the OPMF, or the Oil Pollution Management Fund. Now, while all vessels, channels, and storage facilities that carry or store oil are capable of causing oil pollution, this does not make them similarly situated within the context of the Equal Protection Clause. This is because it is internationally well recognized that oil tankers pose a greater risk to the environment and to people. As a matter of fact, these types of vessels have long been considered as a separate class and are given a different treatment by various organizations. Organizations such as the International Maritime Organization, or the IMO. Um, Under the International Convention for Safety of Life at Sea, or SOLAS, um, the IMO stated that there are fire safety provisions are much more stringent for tankers than in ordinary dry cargo ships, since the danger of fire on board ships carrying oil and refined products is much greater. The IMO likewise mentioned some of the measures specifically required of oil tankers, such as making it mandatory for tankers to have double hulls as opposed to single hulls, the phasing out of single hull tankers, and designating protective locations of segregated ballast tanks, amongst others, in order to ensure their safety. So, I included here an illustration between a single hull and a double hull tanker. So, as you can see, if the if the vessel is only single hull, the moment that it gets penetrated, the oil spill will directly will spill the oil will directly spill into the ocean. Now, on the other hand, if the tanker was double hull, even if the outer hull is penetrated, it does not necessarily mean that the hull containing the oil is penetrated, and thus there is an added layer of safety. So all of this put together, the Supreme Court held that it is valid to classify oil tankers and oil barges from regular sea vessels, and thus the constitutionality of Section 22A was upheld. Central Bank Employees Association versus Central Bank. The facts of the case are as follows. On July 3, 1993, RA number 7653, or the new Central Bank Act, took effect. It abolished the old Central Bank of the Philippines and created a new BSP, or the Bangko Sentral ng Pilipinas. On June 8, 2001, almost 8 years after the effectivity of RA number 7653, Petitioner Central Bank Employees Association filed a petition for prohibition against BSP and the Executive Secretary of the Office of the President to restrain respondents from further implementing the last proviso in Section 15C, Article 2 of RA number 7653 on the ground that it is unconstitutional. The challenge provision provides that a compensation structure based on job evaluation studies and wage surveys and subject to the board's approval shall be instituted as an integral part of the Bangko Central's Human Resource Development Program, provided that the Monetary Board shall make its own system conform as closely as possible with the principles provided under RA number 6758 or the Salary Standardization Act. Provided, however, that compensation and wage structure of employees whose positions fall under salary grade 19 and below shall be in accordance with the rates prescribed under the SSL. So petitioner contends that the aforementioned provision makes an unconstitutional distinction between two classes of employees in the BSP. One, the BSP officers, or those who are exempted from the coverage of the Salary Standardization Law, or SSL, and two, the rank and file or salary grade 19 and below who are not exempted from coverage of the SSL. So the issue before us is whether or not Article 2, Section 15, Paragraph C of RA 7653 is violative of the Equal Protection Clause. And the answer is no, but actually yes. So what does the court mean with this? Um, Congress is the Supreme Court held that Congress is allowed a wide leeway in providing for a valid classification so long as it conforms to the following requisites. So once again, these are the four requisites that we have discussed in prior cases. It must be based on substantial distinctions, must be germane to the purpose of the law, must not be limited to existing conditions only, and must apply equally to all members of the class. So in the case at bar, it is clear in the legislative deliberations that the exemption of officers who are in salary grade 20 and above from the SSL was intended to address the BSP's lack of competitiveness in terms of attracting competent officers and executives. It was not intended to discriminate against the rank and file. Thus, the challenged proviso, on its face, holds no constitutional infirmities. So what the court is saying is here is if we look at the provision in a vacuum, um, there there is no violation of the Equal Protection Clause. However, while RA number 7653 started as a valid measure well within the legislative's power, the court holds that the enactment of subsequent laws exempting all rank and file employees of other government financial institutions or GFIs leached all validity out of the challenge proviso because it was found that after the new BSP charter was enacted in 1993, Congress also undertook the amendment of charters of other GFIs such as the GSIS, Land Bank, DBP, SSS. So listed here are the seven legislations that Congress passed that amended the charters of these GFIs. And it was noted that all of these amendatory laws had a common provision. There was a blanket exemption of all their employees from the coverage of the SSL, expressly or impliedly. So this, the Supreme Court discussed the concept of relative constitutionality. And relative constitutionality means that a statute may be valid at one time but may become void at another time because of altered circumstances. Thus, if a statute in its practical operation becomes arbitrary or confiscatory, its validity, even though it was affirmed by a former adjudication, is open to inquiry and investigation in light of changed conditions. So, applying all of this together, the prior view on the constitutionality of 7653 was confined to an evaluation of its classifications between the BSP rank and file employees and the executive officers of the BSP. And it was found that there was a substantial distinction that merit a valid classification. However, now the inequality of treatment between the rank and file employees of BSP and the employees of all other GFIs who are exempted from the SSL cannot now be justified on the mere assertion that the exemption was given as a policy determined by legislature or some legislative prerogative. Because our legal history shows that GFIs have long been recognized as a single distinct class, separate from other governmental entities. So, in a way, because there was a blanket exemption in other GFIs, the rank and file employees of BSP who for 8 years were not exempt from the SSL, they have been unfairly discriminated against because all their other contemporaries and peers in other GFIs enjoyed exemption from the salary standardization law. So, conclusion: under most circumstances, the court will exercise judicial restraint in deciding questions of constitutionality, recognizing the broad discretion given to Congress in exercising its legislative power. However, if the challenge to the statute is premised on the denial of a fundamental right or the perpetuation of prejudice against persons favored by the Constitution with special protection, judicial scrutiny ought to be more strict. A weak and watered down view would call for the abdication of this court's solemn duty to strike down any law repugnant to the Constitution and the rights it enshrines. This is true whether the actor committing the unconstitutional act is a private person or the government itself, or one of its instrumentalities. Oppressive acts will be struck down regardless of the character or nature of the actor. In view whereof, the challenge provision, section 15, paragraph C of RA 7653 is declared unconstitutional. Okay, so now we're done with the cases on the Equal Protection Clause, and now we're moving to the constitutional right against unlawful searches and seizures. And the first case under this topic is the case of Stonehill versus Jokno. The facts of the case are as follows. So in this case, the respondent judges issued on different dates a total of 42 search warrants against the petitioners, directing any peace officer to search the petitioners, their offices, warehouse, and residences, and seize any of the following personal property. So, books of account, financial records, vouchers, correspondence, receipts, ledgers, journals, portfolios, credit journals, typewriters, and other documents or papers showing all business transactions. This includes disbursement receipts, balance sheets, and profit and loss statements, and even bobbin cigarette wrappers. So, these aforementioned items are to be seized because they are purportedly the subject of the offense, stolen or embezzled proceeds or fruits of the offense, or used or intended to be used as the means of committing the offense in violation of central banking laws, tariff and customs laws, the Internal Revenue Code, and even the revised penal code. So, on March 22, the Supreme Court issued a writ of preliminary injunction towards the items seized from the residences of the petitioners. At this point, the documents, papers, and things seized under the alleged authority of these warrants may be split into two major groups: those found and seized in the offices of the aforementioned corporations, and those found and seized in the residences of the petitioners therein. So now the case devolves on the validity of the search and seizures of the items seized from the office as well as the items seized in the petitioner's residences. So, going as to the office, the Supreme Court held that the items were validly seized because the petitioners have no cause of action to assail the legality of the contested warrants and of the seizures made in pursuance thereof. The simple reason being that corporations have their respective personalities separate and distinct from the personality of the petitioners, regardless of the amount of shares of stock or of the interest of each of them in said corporations and whatever offices they may hold therein. Indeed, it is well settled that the legality of a seizure can be contested only by the party whose rights have been impaired thereby, and that the objection to an unlawful search and seizure is purely personal and cannot be availed of by third parties. Consequently, petitioners herein may not validly object to the use in evidence against them of the documents, papers, and things seized from the offices and premises of the corporations adverted to above, since the right to object to the admission of said papers in evidence belongs exclusively to the corporations to whom the seized effects belong and may not be invoked by the corporate officers in proceedings against them in their individual capacity. So now we move to the items seized from the petitioner's residences. And here the Supreme Court held that the search and seizure was invalid. And to that point, the two important questions need to be settled. First, whether the search warrants in question and the search and seizure made under the authority thereof was valid. And if the answer to the preceding question is in the negative, or if the search and seizure was in fact invalid, whether said documents and papers seized may still be admissible in evidence against the petitioners. So, as to the first issue on validity of the search warrant, the Supreme Court outlined that there are two requisites that need to be complied with. The first, no warrant shall issue but upon probable cause to be determined by the judge in a manner set forth in said provision, and two, that the warrant shall particularly describe the things to be seized. The Supreme Court held that none of these requirements has been complied with in the case of Barr, since the warrants were issued due to a quote unquote violation of central bank laws, tariff and custom laws, internal revenue, and revised penal code. In other words, there was no specific offense that had been alleged in the applications. Thus, it was impossible for the judges who issued the warrants to have found the existence of probable cause. Thus, it is legal heresy to convict anyone of a violation of laws without reference to any determinate provision of said laws. Furthermore, the warrants in question authorized the search and seizures of quote unquote records pertaining to all business transactions of the petitioners, regardless of whether the transactions were legal or illegal. This contravenes the explicit command of our Bill of Rights that the things to be seized must be particularly described, and thus it partakes of the nature of a general warrant. Okay, so now that the Supreme Court has proved that the validity of the search warrants in question was that the search warrant itself was invalid, may the items seized still be admissible in evidence against the petitioners? And as to this, um, the respondent Department of Justice invoked the case of Moncado versus People, where it was held that even if the searches and seizures under consideration were unconstitutional, documents and papers and things thus seized are still admissible in evidence. But however, the Supreme Court held that upon their deliberation, they have unanimously decided to abandon the Moncado ruling. Their reason being that the Moncado ruling relied on American common law rationale that the criminal should not be allowed to go free just because the constable blundered. However, most common law jurisdictions have already given up on this rule, hence the Supreme Court of the Philippines shall also do the same. Wherefore, the Supreme Court holds that the doctrine adopted in Moncado case must be abandoned, and that the warrants for the search of three residents of the petitioner's Stonehill shall be declared null and void, and that the searches and seizures made therein is declared illegal. So that concludes my report. But before I hand you over to my group mate, Ms. Paez, let's have a quick recap on the five cases that I've discussed. So we will remember in the case of Quinto versus Comelec, the main doctrine of this case is even if a classification rests on substantial distinctions between the classes, the classification may still be held as unconstitutional if it is not germane to the purpose of the law. Second, under Philippine Association versus Drillion, overseas Filipino domestic workers are a class separate and distinct from overseas Filipino workers because, because they are generally more vulnerable to abuse from their foreign employers. Third, in Department of Transportation versus Philpetroleum, oil tankers and barges are a class separate and distinct from other sea vessels because their cargo has a much greater capacity to harm the environment. The fourth case is Central Bank Employees Association versus Central Bank. This is the case that discussed the concept of relative constitutionality, which provides that a statute that was deemed valid at one point in time may be deemed void at some other time due to altered circumstances. And lastly, our first case for unlawful searches and seizures, we have Stonehill versus Jokno, where the Supreme Court held that the right to assail the validity of search warrant is personal in nature. As such, the owner of a company may not question the validity of a warrant for the search and seizures of items in the company's office. And with that, thank you for listening, and I hand you over to my group mate, Ms. Paez. Thank you, everyone.
Good morning, classmates. I'm Pamela Paez, and I will be reporting the remaining five cases. So the 11th case is Telen versus People. So this case involves the legality of a warrantless arrest and search, specifically a stop and frisk operation where the defendant was caught with illegal drugs and a hand grenade. So the key issue revolves around whether this warrantless search was lawful under the Philippine Constitution. So the background of the case are as follows. The defendant, Gregorio Telen, was at a gas station in Makati City when a police officer observed what appeared to be a hand grenade tucked in his waistband. The officer called for backup, tailed Telen to a mall, and eventually arrested him. During the arrest, a stop and frisk search was conducted, leading to the discovery of illegal drugs on Telen's person. The regional trial court ruled that the warrantless arrest and search were lawful because Telen was caught in flagrante delicto with a hand grenade, justifying his immediate arrest and the subsequent search. The Court of Appeals affirmed the regional trial court's decision, stating that the arrest was lawful because Telen was caught in flagrante delicto for illegal possession of a hand grenade, allowing the warrantless search. Telen appealed to the Supreme Court, arguing that his arrest was illegal and the evidence seized inadmissible. Telen contends that his arrest was illegal because there was insufficient basis to incite suspicion that he was committing a criminal activity and that the prosecution failed to comply with the requirements of Republic Act No. 9165. The prosecution asserts that Teles' arrest was lawful as he was caught in flagrante delicto with a hand grenade, which justified the warrantless arrest and search, and that the seized evidence was admissible. The issue in this case is whether the stop and frisk search conducted during Telen's arrest was lawful. The Supreme Court held no, that the stop and frisk search conducted during Telen's arrest was unlawful. So, Article 3, Section 2 of the Constitution provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable, and no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. However, the constitutional guarantee applies only to searches and seizures tainted with unreasonableness. A search and seizure can be carried out on the strength of a warrant issued upon a judge's personal determination of probable cause. However, this is not absolute and is subject to jurisprudential exceptions where, despite the lack of a judicial warrant, the search and seizure were held reasonable due to the circumstances surrounding the cases, such as warrantless search incidental to a lawful arrest, seizure of evidence in plain view, search of a moving vehicle, consented warrantless search, custom search, stop and frisk, and exigent and emergency circumstances. To recall, a search incidental to a lawful arrest requires the existence of a lawful arrest as a condition precedent. It is imperative that a lawful arrest happens first before the search. However, there are instances wherein arrest without warrant is lawful, such as when, in his presence, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. Second, when an offense has just been committed and he has a probable cause to believe based on personal knowledge of facts or circumstances that the person to be arrested has committed it. And lastly, when the person to be arrested is a prisoner who has escaped from a penal establishment or where he is serving final judgment or is temporarily confined while his case is pending or has escaped while being transferred from one confinement to another. On the other hand, a stop and frisk is done to deter the commission of a crime. This kind of search is used when dealing with a rapidly unfolding and potentially criminal situation in the city streets where unarguably there is no time to secure an arrest or a search warrant. So this is also known as deterrent searches, which are necessary for law en- law enforcement. Um, it is the law enforcers that should be given the legal arsenal to prevent the commission of offenses. However, this should be balanced with the need to protect the privacy of the citizens in accordance with Article 3, Section 2 of the Constitution, that the balance lies in the concept of suspiciousness present in the situation where the police officer finds himself or herself in. These may be undoubtedly based on the experience of the police officer. Hence, they should have the ability to discern based on the facts that they themselves observe whether an individual is acting in a suspicious manner. A basic criterion would be that the police officer, with his or her personal knowledge, must observe the facts leading to the suspicion of an illicit act. To be valid, a stop and frisk search must be based on genuine reasons, considering the police officer experience and the situation's circumstances. So, the court clarified that while a warrant is generally required for a lawful arrest, exceptions exist, such as stop and frisk searches, which are necessary for law enforcement to prevent criminal activities. Here, the prosecution failed to prove the legality of the warrantless arrest. Its bare assertion that the police officers apprehended petitioner after having been caught in flagrante of illegal possession of a hand grenade is insufficient to clothe the police officers with authority to restrain petitioner's liberty. PO3 Mazo's testimony demonstrates his lack of personal knowledge of suspicious circumstances that would have created the suspicion of a crime being committed or about to be committed, the necessary impetus for him to stop and frisk Telen. Without any other reason, PO3 Mazo had a sense of foreboding due solely to the sight of a metal object on petitioner's waist, which is not a genuine reason to justify the stop and frisk search. Such insufficiency is even bolstered by the fact that PO3 Mazo had to tail the petitioner and pat his right waist before he could confirm suspicion. This decision reaffirmed the balance between law enforcement needs and citizens' right to privacy, emphasizing that experienced police officers should discern suspicious behavior based on observed facts. Thus, the stop and frisk search is unlawful. The next case is Porteria versus People. So this case involves the conviction of Marvin Porteria for carnapping based on circumstantial evidence, including the discovery of the stolen motorcycle's registration documents in his possession during a warrantless arrest. So the background of the case are as follows. Christian's motorcycle was stolen, leading to a police investigation. Marvin was arrested on suspicion of illegal possession of a firearm. During Marvin's arrest, the police found the stolen motorcycle's registration documents in his possession. Marvin allegedly made an extrajudicial confession to the theft. The regional trial court found Marvin guilty of carnapping based on the circumstantial evidence. The Court of Appeals affirmed Marvin's conviction, considering the discovery of the stolen motorcycle's documents as a valid search incidental to arrest. Marvin argues that the search leading to the discovery of the motorcycle's documents was not legal. He also disputes the voluntariness of his extrajudicial confession. The issue in this case is whether the search of Marvin's belongings and discovery of the motorcycle's documents is valid. The Supreme Court held no. The Supreme Court ruled in favor of Marvin, overturning his conviction. The court held that the search of Marvin's belongings incident to his warrantless arrest was not valid as there was no lawful basis for the arrest. Consequently, the discovery of the stolen motorcycle's documents was unlawful. This violated Marvin's constitutional right against unreasonable searches and seizures. The prosecution failed to establish any overt act which could lead to Marvin's in flagrante delicto arrest. There was also no evidence that the arresting officers or SPO4 Pequiras in particular knew of an offense that was just committed and that Marvin was the perpetrator of the offense. SPO4 Pequiras verified the report which resulted in the arrest of Marvin. However, he did not specify the reason why Marvin was arrested, other than the fact that there was a report of a suspicious person. The court cannot determine Marvin's overt actions, which led SPO4 Pequiras to believe that Marvin was illegally in possession of firearms. Clearly, the trial court and the Court of Appeals grievously erred in agreeing with the prosecution because the prosecution established only a suspicion that a crime was committed, nothing more, prior to the arrest of Marvin. Further, the present circumstances do not suffice to fulfill the requirements for a hot pursuit arrest. The prosecution did not allege and prove that SPO4 Pequeras and the arresting officers have personal knowledge of the facts that Marvin had just committed an offense. Neither does the anonymous report of a suspicious person operate to vest personal knowledge on the police officers about the commission of an offense. The Supreme Court um, mentioned the jurisprudence, the Veridiano versus People case, wherein the court ruled on the validity of the warrantless arrest made pursuant to a report of illicit or suspicious activity. Failure to comply with the overt act test renders an in flagrante delicto arrest constitutionally infirm. In the case of Cogaed, the warrantless arrest was invalidated as an in flagrante delicto arrest because the accused did not exhibit an overt act within the view of the police officers, suggesting that he was in possession of illegal drugs at the time he was apprehended. So in this case, the petitioner's arrest could not be justified as an in flagrante delicto arrest under Rule 113, Section 5A of the Rules of Court. He was not committing a crime at the checkpoint. So petitioner here was merely a passenger who did not exhibit any unusual conduct in the presence of the law enforcers that would incite suspicion. In effecting the warrantless arrest, the police officers relied solely on the tip they received. Neither was the search of Marvin's body and the belongings valid as a stop and frisk search. So SPO4 Pequiras modeled his testimony when he stated that the search on Marvin and his bag was due to the information they received that a certain person was seen with a suspicious thing tucked in his waist. So the factual circumstances were ambiguous as to whether the arrest preceded the search or if Marvin was stopped and frisked pursuant to anonymous report the police received regarding a suspicious person. So in order to be considered valid, a stop and frisk search must be premised on the manifest overt acts of an accused which give law enforcers a genuine reason to conduct the search. So the search cannot be based on a suspicion or a hunch. So SPO4 Pequiras in this case did not specify the actions or behavior of Marvin or the factual circumstances occurring prior to his arrest and search. He simply stated that Marvin was arrested due to the anonymous tip. SPO4 Pequiras did not even state how they were able to identify Marvin as the suspicious person referred to in the concerned citizen's report. Hence, there being no valid warrantless arrest, the search conducted on Marvin's body and belongings is likewise unjustified. The next case is Saludai versus People. So in this case, Marcelo Saludai was convicted of illegal uh, possession of a high-powered firearm, ammunition, and explosives following a checkpoint search by the Task Force Davao. But he challenged the legality of the search, ultimately leading to his conviction being upheld. So the background of the case are as follows. Task Force Davao conducted a routine checkpoint near Tefasco Wharf in Davao City. SCAA Junbert Buko, a member of the task force, conducted a search of passengers and their belongings on a bus. A small heavy bag owned by Marcelo Saluday was found containing a high-powered firearm, ammunition, and explosives. Saluday argued that the search was illegal, leading to his conviction and subsequent appeals. So the trial court convicted Saluday of illegal possession of firearm, ammunition, and explosives. They found Saluday in actual or uh, constructive possession of the items without the required license. So the Court of Appeals affirmed Saluday's conviction with modifications to the sentence. So they upheld the trial court's findings on possession and lack of a license. It was also ruled that the search was legal as it was part of a routine checkpoint. Marcelo Saluday contended that the search conducted by Task Force Davao was illegal as it violated his right against warrantless searches and seizures. The prosecution argued that the search was valid as it was conducted as part of a routine checkpoint and that Saludai was in possession of illegal items. The issue in this case is whether the search conducted by Task Force Davao at the checkpoint violated Saludai's constitutional rights against warrantless searches and seizures. So the court held no. Saludai con- Saludai's constitutional rights against warrantless searches and seizures were not violated by the search conducted by the Task Force Davao at the checkpoint. The court cited Section 2, Article 3 of the Philippine Constitution, which allows for warrantless searches and seizures as long as they are part of the routine checkpoints and adhere to established guidelines. So the elements of both of the offenses are 1. The existence of the firearm, ammunition, or explosive. 2. The ownership or the possession of the firearm, ammunition, or explosive. And 3. The lack of license to own or possess. So as regards the first element, the petitioner corroborates the testimony of SCAA Buko on the four important points. That one, the petitioner was a passenger of the bus flagged down at a military checkpoint. Two, that SCAA Buko boarded and searched the bus. Three, that the bus conductor pointed at the petitioner as the owner of a small gray black uh, pack bag on the back seat of the bus. And four, that the same bag contained a .30 caliber firearm with a magazine loaded with three live ammunitions and a hand grenade. So he merely raises up your questions of law and argues that they are admissible on the ground that the search conducted by the task force Davao was illegal. But the court in this case disagrees. So indeed, the constitutional guarantee is not a blanket prohibition. Rather, it operates against unreasonable searches and seizures only. Conversely, when a search is reasonable, Section 2, Article 3 of the Constitution does not apply. Further, Justice John Harlan laid down in his concurring opinion the two-part test that would trigger the application of the Fourth Amendment. First, um, that a person exhibited an actual or subjective expectation of privacy. Second, the expectation is one that society is prepared to recognize as reasonable or is objective. So the Supreme Court affirmed the decision of the CA upholding Marcelo Saluday's conviction for illegal possession of firearm, ammunition, and explosives. So the prohibition of unreasonable search and seizure ultimately stems from a person's right to privacy. Hence, only when the state intrudes into a person's expectation of privacy, which society regards as reasonable, is the Fourth Amendment triggered. Here in this case, the bus inspection conducted by the Task Force Davao at a military checkpoint constitutes a reasonable search because the vehicle was a public transportation where passengers have reduced expectation of privacy. Further, SCAA Buko merely lifted the petitioner's bag. This visual and minimally intrusive inspection was even less than the standard X-ray and physical inspections done at the airport and seaport terminals where passengers may further be required to open their bags and luggages. As regards the warrantless inspection of the petitioner's bag, the OSG argues in this case that the petitioner consented to the search. The constitutional immunity against unreasonable searches and seizures is a personal right which may be waived. However, to be valid, the consent must be voluntary such that it is unequivocal, specific, and intelligently given, uncontaminated by any duress or coercion. So the determination of voluntariness are the following characteristics of the person giving consent and the environment in which consent is given. 1. The age of the consenting party. 2. Whether he or she was in a public or secluded location. 3. Whether he or she objected to the search or passively looked on. 4. His or her education and intelligence. 5. The presence of coercive police procedures. 6. the belief that no incriminating evidence will be found. 7, the nature of the police questioning. 8, the environment in which the questioning took place. And lastly, the possibly vulnerable subjective state of the person consenting. So, the petitioner consented to the baggage inspection done by SCAA Buko in this case because when SCAA Buko asked if he could open the petitioner's bag, the petitioner answered, yes, just open it, based on the petitioner's own testimony. So this is a clear consent by the petitioner to search of the contents of his bag. So let's just also discuss the guidelines which the courts lay down in the conduct of bus searches. So prior to the entry, passengers and their bags and luggages can be subjected to a routine inspection akin to airport and seaport security protocol. In this regard, metal detectors and X-ray scanning machines can be installed at bus terminals. Passengers can also be frisked, and in lieu of electronic scanners, passengers can be required instead to open their bags and luggages for inspection, which inspection must be made in the passenger's presence. Should the passenger object, he or she can validly be refused entry into the terminal. So while in transit, a bus can still be searched by the government agents or the security personnel of the bus owner in the following three instances. So first, upon the receipt of the information that a passenger carries contraband or illegal articles, the bus where the passenger is aboard can be stopped en route to allow for an inspection of the person and his or her effects. Second, whenever a bus picks passengers en route, the prospective passenger can be frisked and his or her bag or luggage be subjected to the same routine inspection by the government agents or private security personnel as though the person boarded the bus at the terminal. And lastly, a bus can be flagged down at the designated military or police checkpoints where the state agents can board the vehicle for routine inspection of the passengers and their bags or luggages. So the court emphasized that Saluday's consent to the search and the circumstances surrounding the checkpoint search justified its legality. The next case is People versus Pastrana. In this case, it involves the nullification of search warrant 01118, which was issued for alleged violations of the Securities Regulation Code or SRC and estafa. So the background of the case are as follows. So the National Bureau of Investigation or NBI sought the search warrant based on the allegations of a fraudulent scheme by the respondents involving foreign investors. The warrant covered a wide range of documents and items in the respondent's office. The respondents argued that the warrant violated the one specific offense rule and lacked particularity. The RTC nullified the search warrant because it violated the requirement of being issued for one specific offense only. The Court of Appeals affirmed the RTC's ruling, emphasizing the lack of specificity specificity in the warrant. The petitioner, the people of the Philippines, argued that the offenses violating the Securities Regulation Code and estafa were intertwined and could be covered by a single search warrant. Respondents Pastrana and Rufina Abad contended that the warrant was issued for more than one specific offense and lacked the required specificity. So the issue in this case is whether the search warrant violated the one specific offense rule. So the Supreme Court held yes, that the search warrant um, is null and void for having been issued for more than one offense and for lack of particularity in the description of the things sought for seizure. In the determination of probable cause, the court must necessarily determine whether an offense exists to justify the issuance or quashal of the search warrant because the personal properties that may be subject of the search warrant are very much intertwined with the one specific offense requirement of the probable cause. The only way to determine whether a warrant should be issued in connection with the one specific offense is to juxtapose the facts and circumstances presented by the applicant with the elements of the offense that are alleged to support the search warrant. The one specific offense requirement reinforces the constitutional requirement that a search warrant should be issued only on the basis of probable cause. Since the primary objective of applying for a search warrant is to obtain evidence to be used in a subsequent prosecution for an offense for which the search warrant was applied, a judge issuing a particular warrant must satisfy himself that the evidence presented by the applicant establishes the facts and circumstances relating to this specific offense for which the warrant is sought and issued. So, in order to be valid, a search warrant must particularly describe the place to be searched and the things to be seized. The constitutional requirement of reasonable particularity of description of the things to be seized is primarily meant to enable the law enforcers serving the warrant to first readily identify the properties to be seized and thus prevent them from seizing the wrong items. Second, leave the said peace officers with no discretion regarding the articles to be seized and thus prevent unreasonable searches and seizures. It is not, however, required that the things to be seized must be described in precise and minute detail as to leave no room for doubt on the part of the searching authorities. One of the tests to determine the particularity in the description of the objects to be seized under a search warrant is when the things described are limited to those which bear direct relation to the offense for which the warrant is being issued. In addition, under the rules of court, the following personal property may be subject of a search warrant. First, the subject of the offense. Second, the fruits of the offense. Or third, those used or intended to be used as the means of committing an offense. Here, the subject search warrant failed to state the specific offense alleged committed by the respondents. Consequently, it could not have been possible for the issuing judge as well as the applicant for the search warrant to determine the items sought to be seized are connected to any crime. Moreover, even if the search warrant number 01118 was issued for violation of Section 28.1 of the SRC, as petitioner insists, the documents, articles, and items enumerated in the search warrant failed the test of particularity. The last case is People versus Andre Marti. So in this case, it involves the conviction of the accused appellant for violating drug-related laws, with the key issue being the admissibility of evidence obtained through a search conducted by a private individual and not government authorities, and its seizure alignment with the constitutional protections against unreasonable search and seizure. So the background of the case are as follows. Accused appellant and his common law wife brought gift wrapped packages to a forwarding agency for shipment to Switzerland. The forwarding agency owner, a private individual, requested to inspect the packages but was denied by the appellant. The owner, before delivery to customs, conducted a routine inspection and discovered a peculiar odor and suspected contraband inside. So the owner reported the findings to the NBI, who later examined the packages revealing marijuana. So the trial court convicted the appellant, admitting the seized evidence. The appellant appealed, arguing that these constitutional rights against unreasonable searches and seizures were violated. The Supreme Court reviewed the precedents and held that the evidence obtained by the private individual without government interference does not violate the constitutional rights and is admissible. So the appellant contends in this case that the evidence was obtained through an illegal search and seizure violating the constitutional rights. So sections 2 and 3 of Article 3 of the Constitution provides that the right of the people to secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable, and no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and the particularly describing the place to be searched and the persons or things to be seized. So, Section 3 um, provides that the privacy of communication and correspondence shall be inviolable except upon lawful order of the court or when safety or order requires otherwise as prescribed by law. Any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding. So since the provisions of the 1935 Constitution has been modified by the present phraseology found in 1987 Charter, expressly declaring as inadmissible any evidence obtained in violation of the constitutional prohibition against illegal search and seizure. It matters not whether the evidence was procured by police authorities or private individuals. So the prosecution argues that a search and seizure conducted by a private individual was reasonable and constitutional. So the issue in this case is whether the evidence obtained by a private individual's search is admissible and does not violate the constitutional rights against reasonable searches and seizures. So the court ruled yes. The Supreme Court ruled that the evidence obtained by a private individual search without government involvement does not violate the constitutional rights against unreasonable search and seizure. This ruling is grounded in the understanding that constitutional protections primarily apply to government actions and restrictions on governmental interference. If the search is made upon the request of law enforcers, a warrant must generally be first secured if it is to pass the test of constitutionality. However, if the search is made at the behest or initiative of the proprietor of a private establishment for its own and private purposes, as in the case at bar, and without the intervention of police authorities, the right against unreasonable search and seizure cannot be invoked for only the act of a private individual, not the law enforcers is involved. Here, the case at bar assumes a peculiar character since the evidence sought to be excluded was primarily discovered and obtained by a private person acting in private capacity and without the intervention and participation of the state authorities. The Fourth Amendment of the Philippine constitutional provisions on search and seizure are concerned with limiting government intrusion into privacy of the citizens, not the actions of private individuals. Also, as enunciated in the case of State versus Bryan, uh, where the parking attendant who searched the automobile to ascertain the owner thereof found marijuana instead, without the knowledge and participation of police authorities, was declared admissible in prosecution for illegal possession of narcotics. Therefore, the evidence obtained through the private search was deemed admissible, leading to the appellant's conviction under drug-related laws because the protection against unreasonable searches and seizures cannot be extended to the acts committed by private individuals so as to bring it within the ambit of alleged unlawful intrusion by the government. So let's review. So in the case of Talon versus People, for the doctrine in this case is that for a stop and frisk search to be valid, it must be supported by evidence such that the totality of the suspicious circumstances observed by the arresting officer led him or her to believe that an accused was committing an illicit act. So a warrantless arrest not based on this violation of the accused's basic right to privacy. Suspicion alone is not sufficient to defeat petitioner's constitutional right to privacy. So here, if you can remember, PO3 Masus mere hunch in the absence of any other circumstance of which he had personal knowledge does not satisfy the requirements for a valid stop and frisk search. In Porteria versus People case, so irreliable information alone is insufficient to support a warrantless arrest absent any overt act from the person to be arrested, indicating that a crime has just been committed, was being committed, or is about to be committed. A hearsay tip by itself does not justify a warrantless arrest. Law enforcers must have personal knowledge of facts based on their observation that the crime sought to be arrested has just committed a crime. In Saludi versus People, warrantless searches and seizures are permissible when the conduct as part of routine checkpoints provided they adhere to established guidelines. So in People versus Pastrana, the sacred right against unreasonable searches and seizures without a valid warrant, as guaranteed by the Philippine Constitution, renders evidence obtained in violation of this right inadmissible in any proceeding. And lastly, in People versus Andre Marti, the private individuals conducting searches and seizures without government involvement do not infringe upon constitutional rights against unreasonable search and seizure. Again, we are Group 5. Thank you for listening.